Good afternoon. My topic is considering victim impact statements. It will be a brief presentation, and I thought to consider basically the legal framework, which Regional Court President Jackie Wessels already dealt with into a great deal, look at the sentencing stage and the relevance of harm, talk briefly about minimum sentences, which you also addressed, some case law for you to see how the courts view your reports and what role it plays together with what other factors, and then have a short conclusion. Right. So it has long been a practice that evidence on harm caused by the crime has been presented to the courts. But it, of course, received more prominence in the recent 2 decades with cases like Machichi and Ramoko and other Supreme Court of Appeal cases that voice the need for victim impact statements, especially in the determination of what the appropriate or just sentence should be. And I'll come to the prescribed sentences in a moment to quickly summarize again how that works. What you must remember is that the sentencing phase is almost like a new mini-trial. New factors are relevant to the court now. What should be the appropriate and the proportionate sentence to be imposed on the accused? What will his future entail? And these things are not relevant during trial when it's all about the elements of the crime. But the court retains the ultimate sentencing discretion. So as it will become clear also later, the victim is not supposed to suggest what sentence the court should impose. Sometimes court do ask that question, but that is not of general practice. Victim impact statements are very important in cases like rape, murder, attempted murder, all in interpersonal violent crimes. Also in the victim's charter, it is embodied that the victim has the right to offer information specifically for sentencing purposes. And as one of the panelists remarked, it must always be remembered that it's not only emotional or physical harm that we talk about, but mental harm, economical harm, and even substantial impairment of human rights is specifically highlighted in the victim's charter. I remember in the Ramoko case, a girl of 13 and a half was sent back to her parents where they lived on a very remote farm, and she could not complete her schooling. She was raped by the neighbor of her aunt. Think of the devastating consequences that action has on the victim in that case. She would never probably go any further and would always remain behind economically, no possible qualification and so on. So secondly, as I said, I want to talk about the sentencing stage specific and the harm-related issues. What would be the value for the victim? Now, in the Mhlongo case, it was said that by the Supreme Court of Appeal that it's the last opportunity to participate in criminal proceedings for the victim. It's also been recognized internationally that the victim impact statement or report provides a voice to tell the court about the after effects of the crime. It's also, in the Machichi case, it was also said it's a dignified way to approach victims. In the Machichi case, there was nothing said about the details of the victim. Partner was murdered and she was raped in a terrible way. So it was glaring that there was no information on who the victims were in that particular case. And that is where the judge then said that information about the victim and the victim's voice should be attended to in criminal cases during sentencing. Concern that is of recent interest is that victims may also choose to exercise their right to privacy. In the Van Breda case, that was a tragic family murder by a teenage boy, the state indicated to the court that there would be no victim impact statement, since the victim's right to privacy would be protected. Now, that was a unique case. There was immense media coverage. The girl, then 20, who survived the attack, was suffering from amnesia and so on. And I think they feared for her life as well. But nevertheless, I think that social workers, when compiling these statements on behalf of victims for court purposes, should tell the victim that they have the right to refuse if they want to regain control over what information becomes public knowledge. They should also know that the court will get this information, the accused and his representative will get the information, and it will eventually become part of court records. Now, I'm sure there are many victims who would like it to be known. So it is not I can't say what percentage, but probation officers must be alert to this possibility as well. What is the value for the court? It has been said by several court presiding officers that they need information in order to impose a proportionate sentence. And the evidence relevant to the after effects of the crime on the victim is certainly a very important part of relevant information that they need. We will look at other factors now, just to summarize here as well, that the evidence in the impact report normally refers to aggravating evidence occurring after the commission of the crime. Mitigating and aggravating factors refer to factors present during and after the commission of the crime. So this is where this report falls under factors relevant after the commission of the crime. It has also been said recently that a victim impact statement can also be of relevance in far as it serves as education to the public. Now, many of you must have been aware of the Nassar case in America, where there were something like 155 victims who had their own YouTube channel, and where they all posted their impact statements. And it's also relevant to, I think, the Hewitt case in South Africa, where victims testified decades after their sexual assault while being girls playing tennis. So it does serve as educational in terms of what is the long-term effect of child sexual abuse in this specific case. The AM case is another case where it was a corrective rape. A 21-year-old lesbian girl was raped by her neighbor while he was telling her he'll show her what a real woman should be like. The harm described in that case is particularly significant, and I think it's instructive to all of us. I will return to that case shortly. Now, thirdly, I want to highlight quickly minimum sentences. Now, Jackie Wessels already referred to the fact that it's not minimum sentences are prescribed for both categories of murder and rape, and in the light of the new amendments, for the most aggravating forms, it's life imprisonment, and they also got a few new categories. And for all other cases, it's now 15 years. So the VIS is one of several factors to be taken into account to decide, and the whole process is compulsory. Should there be a deviation or not? And it can only be done on the finding of substantial and compelling circumstances. So the VIS can fall into that category that can support such a decision or weigh against such a decision. But what is important is that courts want, in the Ganga case it was reiterated, court wants reliable evidence. Some of the panelists also refer to it. It must be, there must be a proper foundation. Social workers must know which symptoms can be attributed to deep harm. The Abrams case is very instructive here. So, firstly, life or 15 years can be deviated from based on the finding of substantial and compelling circumstances. So a lower sentence is then imposed. But you must also know that the sentence can be increased. The sentence of 15 or 10 years can be increased when the case is especially serious but not falling within the category of the most aggravated forms of rape and murder. So, in that sense, VIS can also play a role to increase the sentence. Now that the sentence is 15 years for ordinary rape, it's shocking to say that, or rape falling outside the Part 1 of Schedule 2 offences, it's possible to even argue from the prosecution side that it must be increased to 18 years if it's not pre-planned or it's an adult person, but there are other aggravating factors present.